his error was one of fact, certainly not one of law in a strict sense. It goes hand in hand with the decision that's in the head note.
I think that's true, that if you have regard to the evidence and the inference, you ask to draw an inference from, because it's the only way you can look into a person's mind is from, you judge the subjective intention that that person had by his actions and from the surrounding circumstances. And if that inference is then drawn, it is that he did or did not entertain the intent to kill. That's a factual inference.
And that goes further. It's later in paragraph 29, but it's in a head note where it says, of the same decision, where it says, an acquittal based on an erroneous conclusion of reasonable doubt constitute a question of law, but then it's important where the trial judge is erred as to the legal effect of undisputed or found facts, rather than the inferences to be drawn from such facts. And that's what we submit in this court. Ultimately, when we consider the evidence of the respondent, it is true that to some extent there was a vacillation, but I think that we can explain that. And I'm sorry for doing this, and I won't go to every passage because we've marked them.
Are you finished with R versus B? Are you finished with R versus B?
I've finished with R versus B.
Because I'm not. And if you go further and look at paragraph 31, or lower down in paragraph 29, we cannot regard the provision as excluding the right of the Appellate Division Council, the Appellate Divisional Court, where a conclusion of mixed law and facts such as the guilt or innocence of the accused depends, as it does here, upon the legal effect of certain findings of fact made by the judge or the jury, as the case may be, to inquire into the soundness of that conclusion, since we cannot regard it as anything else but a question of law, especially where, as here, it is a clear result of misdirection of himself in law by the learned trial judge. So if you don't appreciate the law, then it's a misdirection. And further on, in paragraph 31, a question of law may also arise, it seems to me, when the trial judge misdirects himself or herself with respect to the relevant evidence. Indeed, the Court of Appeal in this case reversed the acquittals after concluding that an error of law had arisen due to the trial judge's failure to properly direct himself to all the evidence bearing on the relevant issues. So, if you fail to direct yourself to all the evidence bearing on the relevant issues, then there has not been a proper legal application. Then that is a question of law. And that's confirmed further if you go on, paragraph 33, which is the passage I think that your learned colleague read, but it goes on in paragraph 34. There is a distinction between reassessment by an appeal court of evidence for the purpose of weighing its credibility to determine culpability on the one hand, and on the other, reviewing the record to ascertain if there's been an absence of appreciation of relevant evidence. The former requires addressing questions of fact and is placed outside the purview of the appeal tribunal. The latter inquiry is one of law, so that is reviewing the record to ascertain if there's been an absence of appreciation of relevant evidence. It indicates a lack. The latter is one of law because if the proceedings indicate a lack of appreciation of relevant evidence, it becomes a reviewable question of law as to whether this lack precluded the trial judge from effectively interpreting and applying the law. So if you don't take certain factors into account, which should have been taken into account, you therefore, and in dealing with a legal issue, then the trial judge who does so cannot effectively interpret and apply the law.
But I think that must be a correct exposition of the law.
Doesn't that give you considerable difficulty?
No.
I don't believe on the factual basis, if you look at what the trial court did, and that's what I was at pains in the beginning to say, let's look at the analysis and I'll come to the respondent's case. Let's look at the analysis of the trial court's approach to the state's evidence. The trial
look at
court...
the approach to the question of dolus eventualis.
Yes.
That's, you'll find at page 3329. I now deal with dolus eventualis, or legal intent. The question is, 1, did the accused subjectively foresee the deceased behind the door? And 2, notwithstanding the foresight, did he then fire the shots, thereby reconciling himself to the possibility that it could be the deceased in the toilet?
Yes, but I will come
No,
to that.
isn't that an incorrect the law?
But that was one.
No, is that not an incorrect application of the law relating to dolus eventualis?
I have just the wrong page reference. I was trying to find it to have the exact one.
Oh, sorry, it's 1707. If that's the blue number.
Yeah, the blue number.
1707. Difficulty that I have.
I think if you read the judgment before that, what the court was doing was to first deal with the state's case.
It dealt with dolus directus and found no dolus directus, and then went on to deal with the question of dolus eventualis.
Yeah, but what is important is that it was all connected. When she dealt with dolus directus and in rejecting the state's case, she made certain factual findings that then spilled over into her approach to dolus eventualis.
Maybe so, but this is her analysis of what the issues were in regard to dolus eventualis. And were they correct?
I will submit they weren't, if I may explain it, if I may make the submission.
Because that doesn't seem to me to be dolus eventualis. Because there, and this is where the error in persona comes in, there, the whole definition of dolus eventualis is defined solely with reference to Reeva, whether he knew she was in the toilet at the time he fired the shots. And is that not a misdirection of law?
I submit not.
Because she goes on to immediately find that this court does not support the state's convention that this could be dolus eventualis. On the contrary, the evidence shows from the onset that the accused believed that at the time he fired the shots into the toilet or the deceased was in the bedroom. But he can be convicted of murder on the basis of dolus eventualis even if he did think that she was in the bedroom, because his criminal intent is defined at the person, whoever that person might be, in the toilet cubicle. So was this not a misdirection of law?
I submit not, and the reason why I say this, because that's one part of her finding, and it must be read with the factual findings before it can't be isolated with respect, Justice Leach. And if I may explain.
Well, I need some explanation as to why what she says is the test that she has to deal with dolus eventualis can be correct, because it seems to me to be not.
If I may first summarize, and then I will go back in more detail. The trial court, in analyzing the evidence, first rejected the dolus directus approach. And in finding there, she made two crucial factual findings. The one factual finding was that he genuinely believed that he was in danger. That's the one factual finding. The second factual finding...
Well, I'm not sure if that is so, but if you can draw me...
I will refer to the passages of the findings.
But let's accept that.
If I may just give an overall approach.
Yes.
So the one factual finding that she made is that he genuinely believed that he was in danger and was acting in danger. The second factual finding was that he genuinely believed that the deceased was at the time of the firing of the shots in the bedroom.
Yes.
And that can't be ignored, those two factual findings.
No, I understand that.
Now, it was in the context of that, when she considered dolus eventualis, to say, because it can't be isolated from the state of mind of the respondent, and that's why she absolutely correctly referred to error in persona or error in objecto, but say that that's not what it's all about. Because if I may use an example, if I shoot someone thinking it's A that's going to attack me, and I really believed I'm under attack, error in objecto does not come into it. Whether the person was A or B or C, it does not matter. And that's what the trial court was at pains to say. She said, I look at error in objecto and I understand. I understand the principle of error in objecto. If I shoot someone and I have a mistaken identity, that in itself cannot be a defense.
Which makes my difficulty even more pronounced, that she did correctly set that out earlier, but when she comes here, and this is her finding, these 2 pages are the findings upon which the whole case turns, insofar as dolus eventualis. She never deals with anything effectively but dolus eventualis is excluded because he did not know that she was behind the door.
That's on the one point, but it cannot be isolated with respect, Justice Leach. If I may take you to an analysis.
You see, I accept the 2 premises that you say she'd already just found, but in the light of that finding, her analysis of dolus eventualis, it seems to me, is wrong.
I think that...
Because the issue was not then whether Reeva was behind the whether he knew Reeva was in the cubicle. The issue was he knew a person was in the cubicle.
But I respectfully submit that's not even the issue.
Of course it's the issue.
If you would allow me just to take it back to the 2 factual findings.
Yeah.
And assuming that the factual finding is that he shot because of a perceived danger.
That is a different issue.
If that's the factual finding...
The issue of whether there was the so-called putative self-defense which has been bandied around is something else. We're talking about intent, not unlawfulness. Putative self-defense has to do... Well, self-defense has to do with unlawfulness. Putative self-defense has to do with culpability. But we're talking about intent is to what was foreseeable.
But that's exactly the point that the submission I'm making, Justice Lees. I submit that you cannot, from that piece of the finding, cannot isolate the factual finding that he genuinely believed that he acted in danger.
No, but let's not get sidetracked by that. When he fired the bullets, did he know there was somebody behind the door?
Well, if I may use a different example, Justice Lees, I walk to a place and I fire shots through a door.
Yeah.
I know there's a person, and of course I'm guilty. Of course I'm guilty. Unless I say I fired those shots because I believed I was right in firing the shots.
Yes, no, I understand that, but that goes to the question of culpability. What we're dealing here with is the assessment of whether and culpability in appreciation of whether he acted lawfully. That is not what is dealt with here. What is dealt with here is whether he foresaw. And as I read the judgment, and you must point out to me where I'm wrong, he says it is not dolus eventualis because he did not foresee that it was Reeva.
Just if I may explain it in this way and make the submission, and I come back to what I've submitted, just for present purposes, accepting that a factual finding was that he believed that he acted in defense. It follows that there's one substantial ingredient absent in his actions for liability, and that is that he believed that he acted lawfully. There was no intention to act unlawfully or the knowledge of unlawfulness. So that's missing. And that was the judge's approach. And it must be read with that. So it was the finding by the trial court to say, that is my factual finding. Now, when I now look at dolus eventualis, I need to consider 2 further questions. Because what I do not need to consider, What I do not need to consider, once I find that there was an absence to act unlawfully, it does not really matter who was behind the door, save for the following. And that's where the finding comes in. She says, or the court, I apologize, the court says, there is of course one instance, and it's not in so many words, but if you read the finding, there is of course one instance where you believe, genuinely believe, that you're firing shots at an intruder, but you foresee and reconcile the dolus eventualis that it might not be an intruder, it might be the deceased. And it's in that context that passage must be understood, where the trial court found and say, I've already found now absence of one of the elements of the dolus event. But now I must go further. That in itself is not good enough. I must now consider, even accepting that he lacked the necessary intent for murder, did he not perhaps foresee that it was Reeva in the toilet, the deceased, and did he not reconcile himself? And in that context,
the question of once, if you're going to come with a defence of putative self-defence, and I think you're going to be hard-pressed to bring the facts of this case within that, but if you do come with that, then it's a question of culpability. And that question of culpability wouldn't matter whether it's dolus directus or dolus indirectus.
I agree.
So it wouldn't be necessary if as you said, there's already been some sort of finding that there's a lack of culpability to reissue it. I mean, one just can read what the judgment says.
But I can't, with respect, I can't take that part of the judgment and isolate it from everything else. And what I'm trying to submit is, if you read it with a finding, what the trial court was really doing, to say, well, I found now as a fact that there was a lack of intent to kill. But now I must consider, did he not perhaps think, because that's the intruder theory, and I give him points, I bring that finding out in his favor on the facts. I do that. But now I must consider, did he not in the back of his mind entertain the thought that it could have been, or that it was perhaps, the deceased? And that's what she's doing there. She's saying, I cannot find on dolus eventualis in view of what she's found before. I cannot find that it was dolus eventualis in the sense that he had dolus eventualis vis-a-vis the deceased, because my factual finding is that when he fired the shots, thinking it was an intruder, he genuinely believed, he bona fide believed, that the deceased was in the bedroom. And that is absolute, in law, a correct finding on an analysis of a previous factual finding in relation to dolus eventualis.
But the court now moves on. The court is at that point busy dealing with dolus eventualis. And the learned judge said, the question is, and then those are the two questions that she asked.
But I fully agree with what the trial court was doing, Justice Barton. If I may explain again, she's now already found that he genuinely believed he fired the shots at the intruder. That is now the end of the dolus directus. Now she thinks, with that finding in mind, is that good enough to absolve him from dolus eventualis? And she says, well, let's see, we know he was in the toilet, and I will develop it, but let's see, could he not perhaps have thought, in firing at the intruder, that it was the deceased, and therefore his absence of knowledge of unlawfulness would not carry conviction right through. It would assist him, because if he thought within the time, the frames of dolus eventualis, if he thought that it might be the deceased in the bathroom, it would not assist him that he genuinely believed that he fired shots at an intruder, because that would only assist him in respect of dolus directus. Therefore, if I look at dolus eventualis, I now narrow the question. I've already made my factual finding. I now narrow the question in relation to the deceased, and I say, I cannot find dolus eventualis because my factual finding is that he genuinely believed that she was in the bedroom. It's in that context. And that makes sense to me.
Yeah, but that makes identity, part of the inquiry.
It does not, with respect, and if I may explain my submission. The identity she dealt with, and quite correctly, the court found it is so that if you have a mistaken identity, that it does not give you a defense. But now I find in this case, I make a factual finding that he believed it was an intruder. Whoever that intruder was, that identity won't play a role because it's now dealing with the culpability. The only time, and this identity of error and objector would have no relation to a consideration of dolus eventualis in relation to the deceased. Because she says, I must just now consider whether he did not perhaps think, entertain, that it was not an intruder. So identity does not in that respect come in. We're all known with respect. I cannot argue that if you make a mistake as to identity that you can hide behind it. But once you don't have the required culpability, the required intention, it does not matter. It does not matter in law. And that is her finding. So she was quite correct in saying...
What is your case insofar as this intruder is concerned?
Well,
the issue.
Well, if I may...
He hears a noise. This is a person... He's not confronted with a person. He knows the person is behind the door. And he hears a noise. Could he honestly and genuinely have believed that he was entitled to shoot that noise? To kill whoever was responsible for that noise? Because that has to be established before you can have your putative self-defense.
Well, I approach it differently, but I will respond to the question. My submission is different with respect, Justice Leach, and that is that the trial court analysed this evidence. Because this is now not leaving out part of the state's case, because I've demonstrated that.
Well, the trial court analysed his evidence and found him to be a shocking witness.
Yes.
And an unreliable witness. But then she said that his version, the accused suspected that an intruder had entered his house through the bathroom window, and that he genuinely, although erroneously, believed that his life and that of the deceased was in danger. There's nothing as a whole on the evidence as a whole to suggest that this belief was not honestly entertained. Well, was there anything that showed, apart from a noise, that his life was in danger? Or that he honestly believed that his life was in danger?
Well,
I know we live in times where people break into your houses and things of violence, but this is a person in a small area. He's armed with a firearm. He went to confront the noise, armed himself, went to confront the noise, and then indeed what happens? There's a noise, and then he shoots it.
If I may turn it around in answering the question, I'm sorry, I'm not debating. If I may turn it around, would the finding be he's lying, he was not scared, he did not believe there was someone, and why was he shooting 3 o'clock in the morning into a door? Who would be in your house 3 o'clock if I find that you genuinely believed that the deceased was in the bedroom? That would be the converse. That cannot be.
No, but was his action in shooting into the door, would he have had an honest and genuine belief that he was entitled to act that way?
We submit, yes, and that was the trial court's finding. And it's not that you disregarded evidence there. The state's evidence factually played no role there, because I've dealt with that. It was premised on a very different basis. This was now a pure analysis by the court on factual content before her. And that's a factual question. And what will happen if we reconsider that question and say, trial court, you were wrong. When you found that he genuinely believed that it was an intruder, you were wrong. Your factual finding was wrong, and we're going to make it a legal finding.
I'm not saying that that was wrong, but was there any, on anyone's version or on a finding, that his life, a genuine belief that his life was in danger?
But again, that's the court's factual finding, and what this court will then do is to interfere.
No, see, I don't believe there has been a factual finding made. You show me where the factual finding has been made.
If I might just go to the places. If I must just go to the various places, if you would allow me, Justice Leach. I've marked them. If you just bear with me.
See, the difficulty with a factual finding is it's a factual. The closest I think one gets to it is that the statement that I put to you, that he said this was his version and it hasn't been disproved by the state. That isn't a positive fact of finding that he genuinely entertained this belief,
it goes
especially in the light of the fact that she has found him to be such a poor witness who's given conflicting versions as to why he shot.
If you would just bear with me, I'll find which said was in line. If you just bear with me, I've got a note of all the places. That's fine. If you just bear with me, I've got a note. She starts with the process, or the trial court starts with the process 1704 at the bottom. Where the court correctly said the starting point, however, once was whether the accused had intention to kill, of whom he mistook the asset. Then she goes on what is stated.
Well, she goes on to say the accused had the intention to shoot at the person in the toilet, but states that he never intended to kill that person. In other words, he raised the defence of putative private defence. Well, that doesn't follow.
If I may go to page 1706.
Or do you say it does follow?
What follows after that?
No, I'm
she
saying
develops
to you,
it. Not that in itself, no.
No, so there's a misdirection at the top of 1705.
No, that's not with respect to misdirection. She says, it's a statement that she says.
He never
she
intended
says he
to
states
kill. Yes.
That he never intended to kill.
In other words, he raised the defence of putative private self-defence.
He did.
No, he didn't. It doesn't flow.
Well, I can take you to many places.
Putative private defence is what is then set up
yes.
by Smallberger JA in the De Oliveira case, which immediately follows that, which is not the same.
No,
you can have intent to kill.
What is not the same? From time to time, he said, I fired and I don't know why and I didn't mean to kill. Yeah. But other cases he said, I fired
at the noise.
At the move, I believed the person was coming out and that I was in extreme danger. That's what he says, repeatedly.
Yes, but why did he believe the person was coming out?
He heard the noise, and he says there was a problem with the door. When you opened the door...
And the door didn't open.
But he wouldn't know that at that stage.
Well, he's standing there, doors in front of him. He
But
didn't
that
see the person.
That is now...
He didn't know whether this was a 12-year-old child or a person armed with a submachine
No,
gun.
but that is also thinking away with respect. There stands a man on stumps. He's vulnerable. He's extremely anxious. We see it now from eyes
That's all
where we look
understandable.
back, and we cannot do that with respect. We must take it in its totality, where this man is standing there, and it starts before, where that anxiety started when he's going to the bathroom, believing,
I understand
incorrectly
that.
so, that
I
there's a problem.
understand that.
Why else did he shoot?
Because he perceived that there was a danger, that there was someone in his thing.
But if that is correct with respect, then he could not have wanted to act unlawfully, because he believed the fact that he was wrong is something else. That's culpability. That's negligence.
Did he believe that he was entitled to shoot in those circumstances?
His version is that he believed his life was in danger and he discharged the shots. So you have to read in it. He's not a lawyer.
That must be bona fide.
But it was found to be bona fide. And I was coming to the passage, and that's the factual finding. And if we reject that, of course, if it's rejected, that factual finding, and say, well, he was not bona fide, he just shot for some reason 3 o'clock in the morning, then I have no case. But then I don't know why he shot. Then he wanted to commit murder on someone in the toilet, believing that the deceased was in the bedroom. Why would he do that? It does not make sense. It does not accord with common sense or probability. But when you look at the whole picture, the court found at page 1706, she talks about his erroneous belief that his life was in danger. And they say, then, as a fact, there is nothing in his evidence as a whole to suggest that this belief was not honestly entertained. She goes, that's a finding. After she dealt with that for 4 or 5 pages, where she rejected something, and they say, there is nothing in the evidence as a whole to suggest that this belief was not honestly entertained. Then she goes to 1709. Where she says, the 4th line, it follows that the accused erroneous belief that his life was in danger excludes dolus. That builds on that finding, and she goes on again to 1726 and 1727, where she says, from paragraph, I'm going too fast, I'm sorry. I'm sorry, just partner. It's 1726, where she talks about his version again from line 18. And the version of the accused was that he fired the shots in the toilet because he thought there was an intruder inside the toilet. The sequence of events, namely the shots, the screams, the shouts of help, the sounds of the cricket bat striking against the toilet, the calls made by various witnesses to security to report screams and or shots, are more in line with the version of the accused. That cannot be ignored. And again on 1727, line 11. From the above, it cannot be said that the accused did not entertain a genuine belief there was an intruder in the toilet who posed a threat to him. That's 4 times.
Sorry, what's that last paragraph?
I apologize, Justice Leach. I was a bit quick, I realized. It's page 1727 from line 11.
Thank you.
So 4 times that you come out with the finding that he genuinely believed that he was in danger and that's why he fired. Now, that is the point that we raised right in the beginning. And the first question that must be considered by this court with great deference is whether that finding is factual or not. And it is a factual finding. That finding is not where she left out facts that the state is complaining about. That finding is solely premised on what she listens to, what she observes. And she comes to a finding that I believe in saying that. And the corollary of that finding is this, and she says that I'm unable to find that he had the necessary intention to kill him. What she meant clearly by that when she dealt with the elements is that he had the necessary intent to kill unlawfully, that he believed that he was right. That's a factual finding. And then when one develops that factual finding, she then acquitted him. And I will come back then to the second point. And she says, but that's not good enough. The fact that you genuinely believe that does not absolve you from liability. and I find a guilty argument on culpable homicide. Because you was just so wrong. You were wrong. You were just so wrong. But I'm unable to find, in fact, not unable, I'm unkind to the respondent. I found as a fact that was your genuine belief. That's the factual finding, and that's what we repeatedly said in the heads of argument when we come to this court. It's a factual finding that, and whether the court considers that to be wrong, and that's also in the Canadian law. If I may refer to the R versus B case as well, where it says, it's paragraph 22, just as a party, where he says, however wrong, the Court of Appeal or this court may think that it was in reaching this conclusion. I'm of the opinion, with all respect for those who hold a different view, that his error cannot be determined without passing judgment on the reasonableness of the verdict or the sufficiency of the evidence. And in my view, these are not matters over which the Court of Appeal has jurisdiction. And that's exactly our cases. So we submit, once it's determined, and it is, that that's a factual finding, right or wrong, then we must develop that factual finding and say, where does it take us in law? Can you reintroduce then intent? And that's where the judge was correct and say, but I'm not going to stop there. Let me now consider, did he not perhaps, and I'm going to not to repeat, did he not perhaps take him away from this intruder? Did he not perhaps think it was Reeva? And then the court brought out that finding and say, no, I cannot find dolus eventualis in respect of that, because he genuinely believed, factual finding, that the deceased was in the bedroom. And it's in that context that the finding is absolutely correct.
But are the questions that she asked correct with regard to dolus eventualis?
Yes.
Did the accused subjectively foresee that it could be the deceased behind the toilet door? Is that what a judicial officer asks in these circumstances?
Yes,
is it not that, did the accused subjectively foresee that if I fire through this door, the person behind will be...
No, with respect,
That's
not in the context. If we have an academic debate, that's the question, because we have to consider error and objector. But she has already made a finding now about the intruder. You don't reconsider and say, well, I've already found that he's not guilty because he believed it's an intruder. I've already found that. Now I'm going to stick to an old definition, not the old definition, an open one, and say, well, did he think there was a person behind the door? That's irrelevant, because she's dealt with that. The moment she found that he believed it was an intruder, and she believed that excluded dolus, that was the end of that exercise. So you don't reintroduce.
Then she didn't have to deal with dolus eventualis either.
No, she had to, because the question is then, her finding was in respect of an intruder, her factual finding. So she did not have to introduce the wrong person, mistaken belief anymore, because she's dealt with that. Whether it was mistaken or not, she found an exclusion ground on dolus in law. And she correctly refers to the elevator and says, that's, later on, I'm confused now. She correctly deals with it and say then, and bring out the finding. But then she says, that's not the end of the question. I've dealt now with error, mistaken identity in relation to your culpability. You really thought it was an intruder, and it doesn't matter. And that's why she correctly says, I hear you. I understand error in persona. I understand that it's not a defense, that you made a mistake. But this is not what the case is all about. Because if you look at all the case laws with respect, most of them have an error in persona, where the son or the daughter or the wife or the husband climbed through the window. You have a mistaken identity, but once it has no relation to culpability, once culpability is not present, it does not matter. She then moves on, or the trial court moves on and say, well, that's not the end of the matter. Let me consider now dolus eventualis, but not dolus eventualis as this open concept in textbooks. Dolus eventualis on what's remaining.
And what was remaining then?
What was remaining was it not perhaps, they did not perhaps entertain that it was the deceased in the bedroom.
Yes, but then why does she conclude, if that is so, at 1708. How could the accused reasonably have foreseen that the shots he fired would kill the deceased or whoever was behind the door? So she then brings in somebody else. Clearly, he did not subjectively foresee this as a possibility that he would kill the person behind the door, let alone the deceased, as she thought she was in the bedroom. And the version of the accused was that had he intended to kill the person behind the door, he would have aimed higher at chest level. This was not contradicted. Isn't there a conflation between dolus directus and dolus eventualis?
Let's accept that, Justice. Let's accept that, sir. And let's accept that finding for present purposes is wrong. And let's put it one side.
Are you prepared to accept that this finding was wrong? That this finding, how could the accused reasonably have foreseen the shots he fired would kill the deceased? Do you accept that that was clearly wrong?
That's the court's finding. That's as far as I can go. That's the court's finding, but I submit that it does not resolve the matter. Because if her finding was, in the first place...
But I'm sorry, before we get there, do you accept that this was an incorrect finding?
I cannot make any concession there. I've said what I said about it.
You had to argue not to make the
I had to argue not yet. Thank you for letting me off there, Justice Lee. But I would say it makes no difference. And I've referred you to a very instructive article by Phelps at paragraph 32. And if I may just go there.
Yes, well, I think the learned author got some things wrong there.
That may be, but if I may refer you to paragraph 32, where the following is said.
Just a minute.
Perhaps, I'm sorry if I'm a bit quick.
Is what?
The first paragraph starts, page 32, starts on the dolus eventualis, and the second one.
Is that the numbered 32 or the top 32?
The top 32.
Typed.
The printed page 32.
Yeah.
And I found that to be instructive. She says, perhaps on the facts, it might have been less controversial findings in the circumstances to hold that it was foresight of death. But this was the court's factual finding, and the accused would have been acquitted either way. But then, the important one, even on a finding of dolus eventualis indeterminatus, he would still have a putative defence on the basis of a genuine mistaken belief that he was under attack and acting under lawful self-defence. He would thus lack knowledge of unlawfulness, which would not be impacted by the error in objecto. So we say, even if that's the finding, and even if that finding were to be wrong, let's look at the principal findings. Once the finding on the facts was that he genuinely believed that he fired the shots because he was in danger, it excludes dolus, the one leg, it excludes dolus. And that's the end of the intruder line.
Well, it doesn't exclude dolus, it excludes the culpability.
Yeah, that's why I tried to say the one leg. The one leg of it. The knowledge of unlawfulness. Then we move to the second part to say, perhaps, maybe he entertained that it was not the intruder outside my finding. And she says, but I make a factual finding that dolus eventualis cannot apply because he genuinely believed she was in the bedroom. So he did not think and did not reconcile himself. Whether he was wrong or right, that's the factual finding. He did not. I find that he genuinely believed at the time that she was in the bedroom. Those would be an answer to the main count. Those would be where the error in objective was consumed and the answer on a factual basis on the dolus eventualis. And then the logic step would then be to move on to say, well, I've given you the benefit of the doubt, and she dealt with it. I've given you the benefit of the doubt, but that's diversion. Then I have to move on to negligence, and that's exactly what the trial court. And we say, if we then take the purpose of this appeal before this court, and we look at the questions, we have to do a number of things with respect. on dolus eventualis. We have to draw a line through the court's factual finding that he genuinely believed, whether that's wrong or right. Whether that's wrong or right, we have to draw a line through that factual finding, because once we keep that factual finding, it cannot follow that he should have been convicted of murder. Once we keep the factual finding that he genuinely believed that the deceased was in the bedroom, we can draw a line through the dolus eventualis in the remaining aspect. And then it's instructive to look at the state's, the points reserved, if I may go there. It's page 25 of the heads of argument, where it says, whether the principles of dolus eventualis were correctly applied to the accepted facts and the conduct of the accused, including error in objecto. I've dealt with that. I've dealt with the factual findings, be it wrong, be it right. So that first question can have no legal effect for purposes of section 319. It cannot be. If you look at the second one, whether the court correctly conceived and applied the legal principles pertaining to circumstantial evidence and or pertaining to multiple defences. What the court, the circumstantial evidence don't really come into it, because the state's circumstantial evidence were all focused on dolus directus. When we look at the accused, where the trial court correctly said, I look at his version, and from time to time, he's saying, well, I did not really intend to shoot, and it was just a reaction and so on, but I find, looking at it holistically, I find on the facts, I give him the benefit of the doubt that he genuinely believed that it was an intruder and that he genuinely believed that he was in danger. That's my factual finding. So it's not the question that she mistreated multiple defences. She says, I must look at it, and ultimately it's not for you to come and tell me what you believe the defence is. I must look objectively at the facts. And the fact that you lied is a factor that I must take into account. But that's not the end of the case. And I must ask myself the questions. And she asked the question. She says, well, objectively, the window was open. And so on and so on. So she refers to a number of factual content to say, well, that corroborates you. So although I don't like you, I think you're a poor witness. Not didn't like your evidence. I think you're a poor witness. I understand the onus. And I give you the benefit of the doubt. And I bring out the factual finding in your favour. And that's my finding. So the point, the second point of multiple defences, she correctly analysed it. She didn't leave out something. If you go to the third point, she says whether the court was correct in its construction and reliance on an alternative version of the accused, and his alternative version was reasonably possibly true. It's actually a rewording of the second point, and he says you should not have found that it was reasonably possibly true. But she did not make errors in law in doing so. She may or may not have, it's not relevant, committed factual errors to say, well, I'm wrong in believing you. I'm wrong that you, ultimately, when I look at your version, and it fits in with your screams, it fits in what you told the people immediately after, it fits in with you hitting the door, it fits in with your anxiety. I looked at Dermond's evidence, I looked at the two Oscars, it fits in. Though I'm not really happy with you, it fits in. And I found myself unable to reject your version. Now, that is factual. The Constitutional Court in Basson made it plain and clear. If that is a point to be considered, it's a factual point, you cannot do it. The court does not have that jurisdiction. If I may move on to the second point on 322, Justice Mapati.
Yes.
On 322...
Before we go on to 322, can I just ask you this? Or tell me if you're going to address it now. How do you view Siakoi in the light of the judgment of the Constitutional Court in Basson?
If I may give this answer, you would not have seen in my opposition to the legal points that I raised Siakoi, and you would have not have seen in the heads of argument that I raised Siakoi. Our reading of Basson was that it's really the end of that approach. You have to give it a constitutional interpretation. And though I understand what the motivation is behind the Siekwe case, I'm unable to make submission to say that it's a guillotine point today. I cannot see myself doing that. However, I must say my understanding of Siekwe was born out of the case was born out of a practical one. To say, what do we do now if someone at a full trial and he gets convicted now, say culpable homicide and not murder, and he serves his sentence, and now for some reason you send it back. How are you going to avoid double jeopardy? And the same sentiments were raised by Judge Didcot in Zoko, where he says it's inconceivable. He then distinguished it because he was dealing with 310, but he used the words. He says it's inconceivable that was in mind. But I think, and with respect, I don't want to put it higher, that the practical effect of the Siekwe principle should rather be considered when you consider whether or not to refer a matter back for retrial. That would make better sense to me.
Then all the factors that led to the decision and its predecessors.
Absolutely.
That you could only have an appeal if it was a conviction, and then the state could only appeal if the point of law was to the advantage of the accused rather than the state. All those factors would come.
It must be that. That's how we read it, Justice Leach. The more difficult part was the 322. It didn't really make that difference to us, but I believe there's one interpretation that if one considers 322, that paragraphs, subsections 1, 2, and 3 were intended to deal with the accused position, and sub 4 with the state's position. And it's quite clear, and this becomes clear when one considers subsection 2 and subsection 3, because subsection 2 and subsection 3 deal with the position of the accused. And then only do we find then, what is it then when the state reserves a point of law? And then when one has that in mind, and you go back to the cases.
But sub 1 also refers to a question of law,
Yes,
which has been reserved.
Absolutely, Justice McClantla, but one has to give meaning to it. And it was not without any pain that I tried to give meaning to it. But if you look at sub 1 and you ask yourself, if subsection 1 was, if 1 was there, why is there subsection 4? Because 1 says you can do what's in the interest of justice. An interest of justice may be to refer to retrial. It seems that if you read a proviso to sub 1, it says provided that if you do it, then you may not do it in certain circumstances and certain circumstances. You must find irregularities, and not only irregularity, but one that would give rise to a failure of justice. It seems that it's all connected to the accused approach, the accused position, and also subsection 3, because there would have been no need, if it was not so, to put subsection 4 onto the law books. And that's what happened in the Rosenthal case, where the court found, if I may just, where the court found, with reference to the Old Criminal Procedure Act, where they inserted in the subsection 322 sub 4 was then 369 sub 3. And the court found that here the accused were acquitted, so the only provision available is 369.3. That's for the state. The only provision. The court says there the only provision for that is nowadays 322.4. And exactly the same approach was followed in Zoko just said about this. Zoko is not important here. In Mahmoud, to say that's the only thing that we can do. It's the only thing, and that was on an interpretation that why is there a 322.4 in that section?
But is the other interpretation not the one advanced by Mr. Nell also, that 322.4 must make provision where there are complete acquittals. And if you look at 324, as I said to him, those are procedural defects, irregularities and so on. So the accused wasn't really acquitted on the merits, but on some technicality. And there, the legislature had to make provision for the state to have him retried in another trial.
Now, with respect, though, if you look at 3221C, it tells you that the court can do what's in the interest of justice. The court can order a retrial. It's nothing stop. If that's in the interest of justice, the state does not need the assistance there. It says, make such order as justice may require.
No, but that's not the point I'm making. The point I'm making is this. 3224 deals with where you have complete acquittals, where the accused walks out from the dock outside the doors of the court, based on a technicality. For example, as is envisaged in 324, section 324. There the legislature saw fit to insert a section, subsection 4, to make a provision for the state to charge that accused again. And that's where 322.4 comes in. I mean, why is that not a reasonable interpretation, other than the one that you've advanced?
That is an interpretation. I cannot say it's not an
Why is it unreasonable?
It's a reasonable interpretation, but what we're submitting to you is also a reasonable interpretation that's supported by 2 decisions of this court.
Well, can I then ask you this? If you read 322.1b and c together, now, you've made the point with considerable merit in your heads that there's grave difficulties in envisaging a retrial in this case because of what's gone before in this case. And I understand that. Bearing that in mind, and considering that the entire record is before us, if we find for the state, why can we not, in the interest of justice, that sub C, give such judgment that ought to have been given by the trial court? As I've said, we can't sentence. So in the interest of justice, why can this court not make such an order?
We submit that, and that's again on interpretation. The one is that disjunctively, it's or. It's the one or the other. But those steps we submit are there in the case of a legal point by the accused or a conviction by the accused. Because even if you're given a complete acquittal on a legal point in 3221, then if 3224 was just meant for a complete acquittal, why can't 3221 with respect not also give rise to a complete acquittal?
Well,
if you can introduce the state's question of law there.
Sorry, I'm not quite with you there.
If I may repeat the submission.
Yes, I just need to understand this. Why do you say that 3221 then can't apply in where the state appeals on a point of law, where there's been a conviction?
Where there's a conviction?
Yes. Not a complete acquittal, but a conviction.
It applies, but it doesn't apply to the state.
Yes, but why?
It says in the case of a conviction, the state would not appeal in the case of a conviction. Why would the state appeal? It's clearly meant with respect, my interpretation, to say there's the accused is an appeal against conviction. The state does not have that right to appeal against conviction.
No, but you must read it further. Or of any question of law reserved.
And
question of law reserved refers to section 319. And section 319, and we know the history of that section in previous acts. Section 319 specifically envisages the reservation of a question of law either at the instance of the accused or by the prosecutor. And so I also, like my brother, don't understand how you get to this argument that 322.1, 2, and 3 apply only on your interpretation in the instance of the accused. I don't understand that.
If we look at, if I may start at the back with respect, Justice Majid, if you look at the back and you look at the proviso following sub 1, it says provided that, and it only deals with the accused there. And sub 3 only deals with the accused. It does not deal with the position of the state. That's why. Whilst when you get to 4,
Why
it
do you
deals.
say that? How does the proviso affect it? How does the proviso affect it?
The only submission we make in this regard, if you look at the proviso has no relevance to the state.
Why?
Precisely.
It deals with, it says when a point is decided in favour of an accused, and then it tells you what the court must do and may not do.
But
And
Mr.
the second one is where there's a conviction. That's only
Sorry,
the accused.
I'm sorry I interrupted you, but this is exactly the point. What the proviso does, it makes provision for a certain set of circumstances that may arise where the court finds for the accused. It has no bearing on the prosecutor. It doesn't mention the prosecutor because it doesn't affect the prosecutor. That does not mean, it does not follow, therefore, that the prosecutor is not included in 1, 2, and 3. I'm having difficulty following your argument. You see what I'm saying? This is in to make provision for a set of circumstances that may arise where the accused is successful in raising the point of law. It says the conviction and sentence shall not necessarily be set aside. And one can understand that. From a practical point of view, we know how criminal trials go.
Justice Majid, I understand it, but if I may go back from 3221 to the word question of law, and I understand where question of law comes from, but so does question of law in sub 4 come from, and that's from 319. But that question of law can also incorporate a complete acquittal. It does not say in a question of law other than in the case of a complete acquittal. And for that reason, we say, if you look at that, if you look at 1, 2...
Exercise under 322(4), the accused then couldn't raise a plea of outre-foi.
That may be, and I think a second...
But you see, where we're not dealing with an acquittal, but a conviction, but possibly an incorrect conviction, and if you accept that the court would be bound, the appeal court would be bound on the factual findings that are made, but there was an error of law made, then there would be no purpose in starting de novo. And one shouldn't exercise your discretion then under 3224, but you just make the order that should have been made.
Yeah, I understand that, Justice Leach.
And that would might, in a position like this, operate in an accused's favour, where factual findings have been made that an accused person might be very happy that they were made and not made in favour of the state on certain issues. But then the court is bound by those factual issues, but merely takes the final decision that should have been made. Take, for instance, this case. There's been an inference drawn in so far as dolus. If there's been dolus eventualis, if the court finds it, for instance, that it shouldn't have been culpa, but it was a question of dolus, you don't want to have the whole thing referred back, to start de novo, to go through the whole trial again. It's far easier to say, these are the factual, this is the factual matrix. There was an error of law. So the only factual thing that we're going to interfere with was the drawing of the inference and draw the correct inference.
Justice Leach, I try to make it plain that we also, from our side, we have a difficulty with the interpretation. I could simply give you the two interpretations. Yeah. I hear you. I understand that interpretation. There are two interpretations. What complicated it is, of course, by virtue of previous decisions of this court indicating to us that's the only thing that can happen.
No,
but it's open.
Appreciate
it is indeed open. If I may just come back to the merits on one point.
Yeah.
Sorry, can I just add, before you go to the merits, it's interesting that, I mean, my colleague has referred to you State versus E, but in commentary at 31-39, when the authors deal, commentary on the Criminal Procedure Act, when they deal with the powers of the Supreme Court of Appeal, if the question of law is decided in favor of the state, they say, they refer to the retrial and quote State versus Rosenthal, as you've done, but they also say the following, and I quote, if the record contains all the relevant information, the SCA may also use its powers pursuant to Section 3221 and deliver the judgment and impose the sentence, while we leave that aside, that should have been delivered and imposed by the trial court if the latter court had correctly interpreted the legal position. But again, they quote no authority, so I'm just mentioning it.
Yeah, I saw that. If I may just refer to Pillar in this regard, where I thought, and again with great deference, Justice Mpati, where I thought that the powers really that the court derive were the powers provided for in Section 22 of the High Court Act, to interfere. If I may just go to that passage, it is, and I understand the facts there where there was an appeal and there were acquittals which were not really before the court. But there was in paragraph 114, it says the powers of a court of appeal are derived from section 22 of the Supreme Court Act, which provides for that. And then section 322, and it's quoted, is then reference to, and it says the subsection clearly deals with the powers of a court of appeal may exercise in the instance of an appeal against a conviction or where a question of law has been reserved for its consideration. It does not give a court of appeal the power to alter acquittal order or to substitute it with a finding of guilty. I just bring that to the attention.
I know my brother presiding was in that case, but they may have been wrong.
I will never dare to say that, Justice Mitchell. I just referred to that. If I may just come back to one point on the merits, and I don't want to reinvent the wheel, and leave the factual point behind. When one considers the case and the intention or the negligence, we submit that it cannot be considered by simply saying that you must look at his evidence where it was contradictory and for that reason reject it and find that he did not act in a perceived danger. Because that would so militate against the prevailing facts. It would so militate against all the evidence on record where we have this absolute anxiety that was not in issue, where a psychologist appointed by the court tried to explain the two Oscars, and the one when it's 1.5 meter, and his fears, and his over fears, and his over anxiety. And that was also confirmed by Professor Foster, is general anxiety disorder. And it's that person that you must take and see him hearing a noise, and with his fight response, not the flight response, because he cannot run without his legs on his stumps. With that flight response going there and making observations in that condition, 3 o'clock in the morning. If you think that away, the question is, why did he shoot? Did he just shoot because he decided this is a good time to fire shots into a door? It cannot be with respect. There was a trigger element for him, and that trigger element was a continuous one, where he was standing there in that state of mind, and when he heard that noise, for him it was, that's it. That's it, they're coming out. And he says this on a couple of occasions. If you draw a line through that and say, that's nonsense, you're a liar, you're a poor witness, why did he shoot? Did he just go to the bathroom to fire shots into a door because it's practice time? It cannot be.
But what also cannot be is that the court gave every person with an anxiety disorder a license to shoot.
Absolutely not, and we're not asking for that. We say that's why we can't generalize. We say, let's look at this fact. Are those facts present? We're not saying you're excused from firing. That's why he's convicted. That's why he's convicted of culpable homicide, because he was not excused. But now to impute intention because he contradicted himself, where he was trying to explain his state of mind in very, very difficult situations, is also not fair. So we're not saying walk away. There was no appeal against the culpable homicide. There's no exclusion of liability. But to say that that person went there, and why did he then shoot? If it was not that he was in that anxious moment, overreacting, but in his mind.
One shot, yes.
But we're not talking about one shot where you have a trained person. You shoot. The evidence was in quick succession. Do, 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 do. That's what it was. You trained and you fired shots in quick succession. And you should have thought better. Yes, of course. You should not have fired 4 shots. You should not have fired shots at all. But that does not impact of what his mind was thinking. And that's what the case law, the way I understand the case law, is at pains to say, be careful not to say what he should have thought. Look at his state of mind. And all we say, when you look at his state of mind, you cannot isolate it from who the person is.
How do you say this case differs from State versus De La Vera? How does this case differ from State versus De Oliveira, where the man saw a number of persons in his yard in an area which was prone to housebreaking, crime, and so on, and he fired? And the court found there was no, on the objective facts, there was no imminent danger, and found him guilty on dollars of insurance.
But the court rejected his version. The court rejected his credibility. That's the difference. Here we have a very different case. We cannot just, with respect, take the one case and say, there's a man with 2 legs standing there, it's not 3 o'clock in the morning, he doesn't feel he must protect someone. We have to look at this package. The package presented was very different. And my understanding of the case law, however unreasonable you are, if that's really your frame of mind, that's your frame of mind, and the law is not designed to punish you for a wrong frame of mind.
Well, what the law requires is that you must investigate whether he did in fact hold a genuine belief in the circumstances of the case.
But if not, if he did not hold a genuine belief, what would one say with respect? Why would he have fired? Are we going back to the state's version that he wanted to kill the deceased, which cannot be, which was tested and rejected? It cannot be. Something must have happened in that man's mind that caused him to fire, and he explains that. If you think that away, there's no answer. There's just a person going 3 o'clock in the morning to the bathroom and fire 4 shots on the door. Something must have happened, and he explains this, and the background facts explain it. The experts explain it. It's the package. And it's unfair then to take him and see him now through a prism of someone else standing there at 10 o'clock at night or whenever with 2 legs on. We have this anxious person, the overly anxious person. We see Professor Dermot's evidence where with all the para-athletes, he scored the highest on anxiety. That's the evidence. He's overly anxious.